This radio program is PG-13. Parents strongly caution some material may be inappropriate for children under the age of 13.
The following program is sponsored by Michael W. Smith. The views expressed on the following program are those of the host and not necessarily those of staff, management, or ownership.
Phoenix, this is Brother Mike. You know I'm back on the radio. HardcoreChristianity.com. You are about to listen to the nastiest Christian radio broadcast in the world. You're going to hear the truth, whole truth, nothing but the truth, and we don't care who likes it. Welcome to the program. Today's Bible study, absolutely fascinating. America's Supreme Court. I've got some really wonderful news for you today. Everybody needs to hear it. Please call somebody and tell them about this radio program today. You'll really appreciate listening to it. The Supreme Court. This is Brother Mike. I'm the professional counselor at the Arizona Deliverance Center. We're downtown on 15th Avenue, just south of Osborne. It's a red brick building. HardcoreChristianity.com is the website. All of our ministry services are there. You can get healed and delivered so many different places. For example, we have 2 live services every week, Thursday and Friday nights at 7 o'clock. We have 4 live Zoom services every week, Monday, Wednesday, Saturday, and Sunday. We have a children's deliverance and healing service every Saturday, the 4th Saturday of the month at 10 o'clock. We have discipleship training classes every Tuesday night at 6:30, the 4th Saturday of the month at noon. We're having a women's seminar coming up July 25th, Saturday, starting at noon. My Sunday podcast starts at 9 o'clock. We have a counseling center. You're eligible for free counseling services. If you are a born-again Christian, call me, 602-636-5800. Send me an email, mike@hardcorechristianity.com. May God richly bless you. The Supreme Court of the United States of America has issued some case results that are very beneficial to Christianity in the United States. I thought I'd review them for you today. They're very important cases. You might want to take notes on today's radio program. I wanted to review some of these wonderful decisions that have come out of the Supreme Court, and it's technically, I guess, the result of Donald Trump's appointments to the Supreme Court during his first tenure as president. He made some key appointments, 3 of them, and it has swayed the court a little bit to the right. Check this out. In the case of Arson versus Macon, that was in 2022. In this case, the court ruled that Maine's tuition assistance program, which had previously excluded religious schools, violated the First Amendment's guarantee of religious freedom. The court held that if a state provides tuition assistance to private schools, it cannot exclude religious schools simply because they are religious. Can you imagine that? It's the Arson versus Macon case. It came out in 2022. That means here in Arizona or whatever state you live in, religious schools cannot be excluded. Case number 2, Groff versus DeJoy. This case came out in 2023. Here's what happened. The court decided with a former postal worker who claimed his religious freedom was violated when he was denied Sunday off to observe his Sabbath. Okay? This postal worker was a Christian, and the United States government, the post office, wouldn't give him the day off to celebrate his Sabbath and let him work another day. They said no. The court clarified the standard for unique hardship, quote unquote, undue hardship. under Title VII, requiring employers to show more than a minimal burden to deny religious accommodation. That means what the court said was, if it was not a significant reason, the employer has to acquiesce to requests to have Sunday off for Christians or Saturday off for Jewish workers, if it is not an undue hardship to the employer. If it's simply juggling a schedule, they have to do it. Case number 3, Kennedy versus Bremerton School District, came out in 2022. The court ruled in favor of a football coach who was fired for leading prayer with students on the field after the games, after school hours. The court held that the coach's private prayer was protected by the First Amendment and that the school district's actions violated his religious freedom according to the ACLU. Can you imagine that? It's one of the few times the ACLU ever stood up for a Christian football coach. He was praying after the games. They'd huddle up and say a word of prayer, or they'd pray in the locker room. And the school said, hey, you can't do that. We don't want any Christianity or religion in our school. Bremerton School District. And the court said, no, you have to allow it. It was fantastic. Check this out. The next case, Fulton versus the City of Philadelphia. This case came out in 2021. The court ruled that the City of Philadelphia violated the First Amendment by terminating its contract with Catholic Social Services because Catholic Social Services had refused to certify same-sex couples as foster parents due to its religious belief. Now, this is big. That one was big. A religious institution doing social service work can impose restrictions on their services based on their religious beliefs. So what the Catholic Social Services wasn't doing, they were not certifying same-sex couples as foster parents. They thought it was bad for the kids. They thought it was immoral. Well, the city of Philadelphia said, hey, you guys are fired. Same-sex couples are fine. And the court ruled in favor of the Catholic Social Services. Fulton versus the City of Philadelphia, 2021. Fantastic ruling. Next one. Are you ready for this one? The United States versus Scarametti. Check this out. Families were wanting to turn their minors over to doctors and hospitals to transition them from one sex to the other. And they wanted to change their sex and engage in gender mutilation and gender mutilation. Hormone therapy, for example. Puberty blockers, for example. Surgery to remove their genitals. Transitioning a boy into a girl who is a minor. Cutting off their scrotum and their penis. Creating a fake vagina. in a boy transitioning into a girl. Okay? Well, a bill was signed by the governor. His name was Bill Lee of Tennessee. This is a Tennessee case. And the ACLU challenged them. But the Supreme Court, in a 6-3 ruling, said that the state of Tennessee could restrict transitional surgeries and transitional gender-affirming care to minors. The Tennessee law, SB 1, was upheld by the Supreme Court. It protects kids who've been wrongly convinced they were born in the wrong body from ruining their anatomy with puberty blockers, hormone therapy, and gender mutilation surgeries. The ACLU made a terrible mistake in the case. They argued that gender-affirming care was protected under the Equal Protection Clause of the 14th Amendment, and that Tennessee's law was discriminatory toward a peculiar sexual orientation. This argument was based on a previous case, Bostock versus Clayton, in which a person can't be denied a job based on sex, sexual orientation, or gender identity. This was a major mistake by the ACLU taking this case up to the Supreme Court. Major screw up. They lost and lost big. That means that here in Arizona or any other state, you can pass a bill restricting gender-affirming care or transition services for minors. It is legal to do that. It's legal to do that. And what's happening is, you can see the Supreme Court kind of drifting to the right on all these subjects. And it's going to have major social implications. For example, gender-neutral bathrooms, men and women's sports, sexually explicit children's books in school. And eventually, it's going to get to the redefining marriage. Marriage used to be, by law, between a man and a woman, a biological male and a biological woman. Eventually, I'm predicting we'll see that overturned because the court is drifting toward the Lord. See you next time.
The views expressed on this program are those of the host and not necessarily those of staff, management, or ownership. This program was sponsored by Michael W. Smith.